Good morning. I am Jayashree from Institute of Sai. I take classes for Judicial Services. Now we will start with the next part of CPC, that is part 4, suits in particular cases. Okay, suits in particular cases means for particular set of persons, or say for example the best example would be the government. Okay, so suits in particular cases means for specific persons or a group of body. Okay, so first we will take up suits by or against government or public officers in their official capacity. See, already we know, we have been reading, right? We are not new to law. What does it say when it comes to personal capacity as a person? Okay, there are certain duties and liabilities, right? So if a suit has to be filed, or if a case has to be filed, or anything like that, then surely it can be filed if the person is in his personal capacity, he does something, right? But when it comes to official capacity, then the story is different. Why is it so? Because official capacity, each person has their own duties and responsibilities, right? So when each person has their own duties and responsibilities, and they do certain acts or omit to do certain acts because it is one of the duties that they have to do. Okay, it is a part of their duty, so they try to do something or they omit to do something. Both ways, commission and omission. Okay, in that case, because it is in their official capacity and they are doing it as relating to official capacity, no case can be filed against them. Sorry, no case can be filed against them. Clear? So therefore, that's why you have it as suits in particular cases. Why? Because here we are going to talk about filing of cases against people who do or omit to do certain acts in their official capacity. Okay. Section 79. Suits by or against government. Government means what? It means the state government or the central government. Simple, right? So whenever there has to be a suit which has to be filed against a government, it can be either against the state government or it can be against the central government. Clear? So it can be filed. There is no hitch in that. There is nobody who can say that no, you cannot file a case against the government. It's not like that. It's a democratic country. We have all the rights. Okay. Section 80, notice. See, this is very, very important because as we already know, all the civil cases need legal notice to be sent first to the other party. Wherever there are problems, there are obviously two or more parties, right? So the party who is asking for the right or claiming against some person, whatever is the situation, okay? So in that case, the person has to give a legal notice to the opposite party, as we call them, okay? So notice is very important for all civil cases, more so in the case of suit against government. We'll go through it now. Save as otherwise provided in subsection 2, no suit shall be instituted against a government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity. Underline the words official capacity. Okay, until the expiration of 2 months next after notice in writing has been delivered to or left at the office of central government or state government or any other public officer. Clear? So what does it say? Notice has to be sent whenever a person has been doing something in his official capacity, either doing something which is not in his official capacity or omitting to do something which is in his official capacity. Okay, then a suit can be filed against such a public officer or a state government or central government. So when it is filed like that, legal notice has to be sent. Okay, once the legal notice has been delivered to the person who wants to file a case against the state government or central government or any public officer of the government department, the person has to wait for 2 months and then file a suit. Clear? So from the date of delivery, that's how you should remember it. In the case of a suit, to whom should the notice be sent? Okay. In the case of a suit against the central government, except where it relates to railways, it should be sent to the secretary to that government. So, secretary to that government obviously it will be the secretary, because that is the highest post. Am I right? So, secretary to that government. Or second one, in case of a suit against central government where it relates to railway, then the central manager of that railway. Okay. In the case of a suit against the government of state of Jammu Kashmir, the chief secretary in that government or any other officer authorized by that government in this behalf. Of course, now it is not like that, because Jammu and Kashmir no special status. I hope you are all aware of that. The special status has been taken away. Then next one, in the case of a suit against any other state government, the secretary of that government or collector of the district. Okay, so it can be against the secretary of the government or the collector of a particular district when it comes to state government. Okay, when it comes to central government, it is only the secretary to that government. Okay, you have chief secretary and all that, right? So, like that. Or if it is some government department, then it should be the secretary or to that government department. Okay, and in the case of a public officer delivered to him or left at his office, stating the cause of action, name, description, place of residence of the plaintiff, and the relief which he claims. And the plaint shall contain a statement that such notice has been so delivered or left. See, this is common. See, whatever we are reading here for notice, now this is common for all the cases. But now, since we are reading about the governments, we will stick on to it. Okay. So, if it involves any public officer specifically instead of the government department as a whole, okay, or the government itself as a whole, then it has to be given to the public officer. It can be either delivered to him personally or left at his office. What all should be there? Okay. Name of the plaintiff, address of the plaintiff, what is the cause of action? Cause of action means reason for filing the case. Am I right? The name, the description and place and residence of the plaintiff and the relief claimed for. Okay. Along with all this, I'm sorry, all this should be there in the notice, as well as all this should be there in the plaint also, along with the fact that the notice has been served on the public officer. Okay, the next, number 2. A suit to obtain an urgent or immediate relief against the government or any public officer in respect of any act purporting to be done by such public officer in his official capacity may be instituted with the leave of court without serving any notice. Underline please. Without serving any notice as required under subsection 1. But the court shall not grant relief in the suit, whether interim or otherwise, except after giving to the government or public officer a reasonable opportunity of showing cause in respect of the relief prayed for. So, notice is compulsory, but if notice is not served, then if the plaintiff is directly filed to the court, okay, then in that case the court will not immediately give any interim relief also. See, for example, if there is some temporary injunction, okay, something like that, So, immediately interim relief will not be provided. Case also will not be decided finally unless the government or the public officer has been intimated about the case and sufficient opportunity is given to show cause as to why the relief should not be granted to the plaintiff. That means what? Why the relief? See, plaintiff has claimed a relief. Why it should not be given to the plaintiff? So, the government has to give sufficient reason as to why the relief should not be granted to the plaintiff. Okay, that is what the case is all about. Am I right? Evidence, arguments and all those things. Provided that the court shall, if it is satisfied after hearing the parties that no urgent or immediate relief need be granted, return the plaint for presentation to it after complying with the subsection 1, right, of section 80. Okay. So that means what? The court will take up if it is an urgent matter. Clear? Even without giving notice to the government department or the public officer, the person can file a suit against the government or public officer. If it is urgent, the court will take it up and then inform the government about this particular case. But after going through the case, if the court feels that it is not that urgent, okay, then the plaint will be returned to the plaintiff and notice shall be sent to the government, either central or state or public officer, and then the plaint shall be instituted once again. No suit instituted against the government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity shall be dismissed merely by reason of error or defect in the notice. Okay, error or defect, we have already seen what the notice should contain. Relief claimed for cannot be denied just because of some technical error in the notice. Okay, say for example, the plaintiff has not written his name, or his name will be there, probably his address, probably the door number of the address is wrong, something like that, small technical errors. Just because of that, it doesn't mean that the court shall not grant the relief due to such technical error. See, but if there is no cause of action at all, then obviously it's not a technical error, am I right? It is a very serious thing. So obviously the case will be dismissed. So you should know what is the difference between technical errors, minor errors, okay, minor technical errors, not major ones, and what all has to be written down in the notice. Okay, then we go to section 81. Okay, exemption from arrest and personal appearance. See, whenever a suit is filed against the state government or central government or any public officer, they can be exempt from personal appearance. Because they cannot keep coming to the court every hearing date and say, I am present, Your Honor. It cannot be done, right? They have other work also. Though we also have other work, but it is a difference because they are doing public duty. Understand? Because they are doing public duty, they can be exempt from their appearance before the court. Every hearing date, it is not necessary that they should appear. If their advocate appears, that's more than enough. Clear? So, exemption from personal appearance, like how when other parties file cases, they should be present before the court every hearing date, right? But it is not necessary when it comes to central government or state government or any such public officers. Why? Only reason because they are doing public duty, nothing else. Okay. Then exemption from arrest and personal appearance. Arrest also, if it is done in their official capacity. Okay, if it is not in their official capacity but it is in their personal capacity that a case has been filed, then they can be arrested. Personal appearance cannot be exempted. Okay, if it is in personal capacity, they are like any other individual. But when it comes to official capacity, they are a different set of persons. Okay, so they can be exempt from personal appearance as well as they can be exempt from arrest also. Just because they have not done, they cannot be arrested. If it is done in official capacity, that you should remember. Okay, I'll just give you a small example. Few years back, there was an ambassador, I think French ambassador, I don't remember now. There was an ambassador in Bangalore, okay, who had to be arrested. But then he kept on saying that he is an ambassador, he is an envoy. So he has special privileges. Clear? But then the court came down on him and said that the case here which has been filed against you by your wife is not in official capacity, is not against you in official capacity, it is against you in personal capacity. So you cannot be exempt from personal appearance, you cannot be exempt from arrest also. Of course, he was arrested. Okay, and the case went on, but I am just giving you an example so that you will know the difference. The next one, section 82, execution of decree. Where in a suit by or against the government or by or against a public officer in respect of any act purporting to be done by him in his official capacity, decree is passed against the Union of India or the state government or the public officer, such decree shall not be executed except in accordance with the subsection 2. Okay, so execution of decree, ordinarily what happens? Whatever is the decree that is implemented against the judgment debtor, right? But here the judgment debtor is not a normal person. It is the state government or the central government or the public officer who is acting in their official capacity. So how should the execution be done? The provisions, execution shall not be issued on such decree unless it remains unsatisfied for the period of 3 months computed from the date of such decree. So what is the condition? The I think you would have read Limitation Act. When we see the Limitation Act, when should the execution case be filed? Within 30 days, right, of the of the decree, right? So when it comes to the government departments, whether it is central government or state government or whatever it is, it shall not be executed unless the claim has not been satisfied. Whatever is the decree which has been given by the court, if it is not satisfied by the judgment debtor for a period of 3 months from the date of decree, then execution can be filed. Not until then. Okay. The provisions of subsection 1 and 2 shall apply in relation to an order or award as they apply in relation to a decree. If the order or reward is passed or made against the union or state or public officer in respect of any such act as aforesaid, that's what it is, it is again and again the repetition. Whether it is an award or whether it is an order or whether it is a decree, doesn't matter. Okay. See, there are differences between order, award and decree. Am I right? I think you must be knowing that. But whatever is the final one, whether it is an order or award or decree, it shall be executed only after 3 months if the claim is not satisfied within the 3 months of such decree. Okay. And when it is executed, it shall be executed against the state government or central government or the public officer. Okay. In their official, who have acted in their official capacity, and is capable of being executed using the provisions of this code as any other law for the time being force. Okay. So how will the execution against the central government or the state government or the public officer be? It will be in the same manner as given under CPC. So the execution procedure will be the same. Only thing is the limitation time for executing the decree. That's it. Clear? Then next we go to section 83. When aliens may sue. When can the aliens sue? Who are aliens? You don't have to go to Krish 2, Krish 3 and all those things. Okay, here when we say aliens, aliens means foreigners. Alien enemies residing in India with the permission of the central government and alien friends, basically foreigners, okay, may sue in any court otherwise competent to try the suit as if they were citizens of India, but alien enemies residing in India without such permission or residing in a foreign country shall not sue in any such court. Why do we say alien enemies and alien friends? See, they all belong to a country other than India, okay? So that's why they are known as aliens. They can be enemies, they can be friends. Of course, enemies, when a war has been declared, then the topic comes up about alien enemies, not otherwise, right? So otherwise everybody is an alien friend only, okay? So when can an alien enemy, if it is an alien enemy, that enemy should be residing in India only when with the permission of the government. If the person or the group of persons are residing in India without the permission of the government, then obviously it is illegal, am I right? Okay, so they cannot sue. They don't have the right to sue at all. Clear? So alien enemies and alien friends who are residing in India with the permission of the government have every right to sue against any party or any government. Party, I mean, it is not political party, any person. Okay. So any person or any government or public officer, just like how every citizen of India has the right to file a case. Clear? So, if they are residing here with the permission of the government only. Clear? The next one, 84. When foreign states may sue. A foreign state may sue in any competent court provided object of the suit is to enforce a private right vested in the ruler of such state or in any officer of such state in his public capacity. So, it is a private right, but it can be enforced by any other foreign state. Clear? See, for example, when we say private right, say, for example, some of the, some citizens are residing here, okay? So, when it comes to any case against a citizen or something, the state has the right to interfere. The person from that country can interfere, the government can interfere, and then say, of course, it's a private right of the person, but we would like to interfere in official capacity. Clear? So, foreign state may sue in any competent court provided object of the suit is to enforce a private right vested in the ruler of such state or in any officer of such state in his public capacity. So, the right is a private right, but the private right arises out of what? Arises out of the public capacity that the person is holding. See, for example, we have all these extraditions and all that. Am I right? So, it is a private right of every government to say that, say, these people belong to our native. You send them back to us. We will try. We will take up the case and we will do it. Clear? So, that is just one example. Next, we go to the next section. 85. Persons specially appointed by government to prosecute or defend on behalf of foreign rulers. Central government may at the request of the ruler of a foreign state or at the request of any person competent in the opinion of central government to act on behalf of such ruler, they will give an application to the central government saying that please appoint somebody who can defend our case or who can institute a suit in our favor. Okay? As an appointment under this section shall be made by for the purpose of a specified suit or of several suits, or for the purpose of all such suits as it may from time to time be necessary to prosecute or defend. Number 3, a person appointed under this section may authorize or appoint any other persons to make appearances and applications and do acts in any such suit or suit as if he were himself a party thereto. So, what are the 3 things? 1, the foreign ruler shall apply to the central government and say, please appoint a person to defend us or to institute a suit on behalf of us. Number 2, such a person can be appointed by the central government and he'll have all the rights of representation before the court. Okay. Number 3, if that person himself is unable to attend, he can appoint somebody else, delegation of authority, am I right? So, he can appoint somebody else to represent him before the courts or before the government or whatever it is. And in this, how can it be? The person can be appointed either for one case or for a series of cases. Clear? Provided that a person may as a tenant of immovable property, So, these are the 3 things which shall be assigned to the central government. Okay. We will stop with this. We will start with the next video. Thank you.